Now, the former governor of Kogi State, Yahaya Bello, has continued to evade calls by the Economic and Financial Crimes Commission to show up for questioning. There are calls challenging his continued refusal to be interrogated following allegations of misappropriation of funds by the EFCC. The latest is coming from the former governor of Benue State, Ortom, who called on his Ortom, who called on his colleague Yahaya Bello to show up for questioning and clear the air. A clear conscience, they say, fears no accusation. Mayor, let me come to you on this. I think I saw part of what the former Benue State governor was saying, because he's, according to him, if he continues hiding, he's sending the wrong signal to all the governors that, they're not really incompetent, but he's sending the wrong signal about the governor. So he should come out, even if he doesn't have anything to hide, he should, go out for interrogation and just face the music, more or less. But what's your thoughts on how, things have gotten, or let's say degenerated over time, since he was being accused, allegedly, of fraud, money laundering, and the aftermaths thereof?
You see, EFCC is a very important agency. And corruption is a major problem that we have in this country. I consider that. But if we want a country that is anchored on the rule of law, then we must be seen to follow the rule of law. Personally, I don't like the style of the EFCC chairman.
Right.
The EFCC chairman is doing like what he's doing, the things he does and say, were the things that the director of media in EFCC should be doing. It is wrong, absolutely wrong, for the EFCC chairman to call a press conference and be discussing matters of a case that is in court.
Yes. Right.
It is wrong. As a lawyer, he knows that. He should know that. So when you do a press conference and you are trying to do trial by media, that is not right. That's number one. I concede that there was a time there have been some governors that have been to court and got injunction that they should not be investigated or tried. I don't agree to that.
Right.
I think the EFCC should have the right to be able to investigate anybody. But EFCC is not the court. So EFCC cannot find people guilty. What EFCC can do is to bring the case to the court, and the court, based on the facts adduced, will decide whether the person is guilty or not. But in this case, there are some issues that we have to look at. Yahaya Bello went to court. For whatever it is, got a judgment from a court.
Right.
EFCC went to another court. EFCC argument is that, yes, the court agreed with him that they should protect his fundamental human rights, but the court did not stop them from investigating him. And that what they have done is to go to a court of competent jurisdiction to get an order for his arrest. Why I don't agree with that is that people always go to court. We discussed this one time, when people go try to get ex parte orders. The ex parte order is that the other party was not present when you were getting that order. You understand? If the person had been put on notice, all the facts will have been put in front of the court, and the court will have been in a better position to come to a better decision. So, the court, for example, may not be aware that there is a judgment concerning fundamental human rights for Yahaya Bello.
Right. When
they were issuing that order. In fact, they know that, because if you notice now that the appeal, they've withdrew the appeal, and now he has been served through subsidiary means, through his lawyers and all that. But I think that the EFCC should not muddle the water. Now that the client wanted or are complaining that he has not shown up, has been overtaken by events. As far as I'm concerned. Why did I say so? Because he has been served. He has been served by his lawyer, and there is a date for him to appear in court. You understand what I'm saying? So it is when it doesn't appear on that set date in court that you can now say he's liable or you can declare him wanted. You understand what I'm saying?
Right.
Because the court of competent jurisdiction, the court that you two went to, has said that, oh, they should serve him through his lawyers. Through substantive means. And now they've done that through his lawyers. So he cannot say he's not aware that EFCC wants him to come to court. His lawyers will brief him accordingly.
Yes.
So since he has been served, let everybody maintain status quo ante until the date that they are going to go to court. Looking for him or complaining that he has not given himself up, or some people advising him, as far as I'm concerned, is irrelevant.
Oh, yes.
Absolutely. It's irrelevant because there is no need for us to advise him, go and give yourself up and all that. He has been served. He has a date in court. Yes. Let's wait for that date in court.
Well said. Biko, your thoughts on this?
Yes, I agree absolutely with Mayor on this matter. The matter of the arrest warrant is already before the court. It's been argued and is subject of argument before the court. As far as Yahaya Bello's lawyers are concerned, if the court,
go ahead.
If the Abuja court had been aware of that order, they would have. It probably would not have given that order. That is what the argument,
right.
And they've come before the court to say, "Oh, what do we do in this circumstance?" The way it is now, May 10 is the date. May 10 is the date for the court to decide.
Right.
That is the date for the court to decide on whether to validate that warrant or not. But one thing is certain: when people say, "Oh, Fayose went by himself," or when Ortom says he should have gone, the circumstances are different. This person got a restraining order. Fayose didn't get a restraining order. And when you get a restraining order, you as a person will not on your own now go against an order that you validly got. That is the point that people are not talking about. I cannot, as a woman, for example, maybe I went to court and got a restraining order against my husband that I should not come like 1 kilometer close to where I am. I will not then take myself before him go to the front of his house. This is the thing. This is the
argument.
The argument. So I would advise the EFCC to focus on winning court cases, leave the drama. The issue of $720,000, for example, is before a court. And then you come before the press to talk about it in a manner that makes people wonder whether you are a trained lawyer. That's no need for that. And in the process, even those minors, you've exposed them to ridicule. Those children, he had been paying for those children since 2021. And you said that at the point when he wanted to leave office. Come on, these issues are not necessary. I appreciate what the school has done in good faith. You know, it's an American school. They don't want disturbance.
Yeah.
They said, okay, we are giving you this money. When the matter gets resolved, you can then return to us. Releasing that money to the EFCC is not proof that the money was taken from government coffers. You have to prove in court that that money was taken from government coffers. With what banking instrument, you have to prove all of that. So this is the crux of the matter. Right. I still think that if the EFCC will not busy itself with trying to win in the court of public opinion, it will be able to win a lot more of these cases because, as I said, it has a very bad record in prosecuting politically exposed persons. Right. And if it says it doesn't have a bad record, we can do a program here that will take us 2 hours. We'll be moving from person to person. Dimeji Bankole, Hassan, the former works minister, all of them that have been set free by the courts. You have to focus on doing the job.
Yeah, due diligence. Yeah, I agree with that position there. Well, we also have in the House lawyer, Barrister Matthias Emeribe. Good to have you on the program. Thank you so much for being here with us. So let's understand this issue. You're a lawyer, and we need you to, make it more clearer for us, because some have said that the case involving Yahaya Bello and the treatment the EFCC had given this matter, it wasn't well, coordinated. The EFCC shouldn't have done what it did, because Yahaya Bello got a court order restraining the EFCC from arrest, and now we also had the issue that the EFCC chairman was being asked to, appear before it, why it should not be arrested for contempt of court. But, help us make sense out of all this. Who was in the wrong, who was in the right, and what should have been the right process in this case involving the former governor of Kogi State?
Thank you very much. Let me say here, with the greatest respect, that we first must admit that the system we run or we operate is a democratic system which is anchored on the rule of what? Law. The implication, therefore, is that everybody will subject itself to the what? To the superior authority of what? The law. Now, when there tends to be a negation or a deviation, the import or the effect from the individuals has its own problem or its own effect, talk less of when you talk of an institution of government. We are not saying that EFCC, for me, does not have right to arrest Yahaya Bello, particularly by virtue of the law, whether you call it the Criminal Administration of Justice Act, or you call it the Constitution itself, or even the EFCC Act. They have a right and the power to arrest anybody. But to the extent that we have a situation where I was watching, even on your television, where the chairman of the body, of the institution, in other words, the symbol of that particular body, went to the media. And for me, that was a fundamental mistake and a fundamental error on his part. And for all intents and purposes, I understand that he's a lawyer. There are things you don't discuss on air. This is because what? You are dealing with an institution that has all the machinery to get the culprit, or better still, the suspect, wherever the suspect is. Now, and if you decide to say you want to do a media trial, you ask yourself a fundamental question. What do you want to achieve by this media trial? Or you are asking that the media should be the one, or the public should be the one to convict him first before taking him before the court of law? Or you are simply saying that you don't have confidence in our judicial system by virtue of that action? For all intents and purposes, this for me is a no-no. And that is where I feel that the institution of the EFCC have done wrong. Right. Therefore, for me, it is for the chairman in question. For all intents, first, he has been invited to Kogi to face a charge of contempt. And that is because of the fact that he went out of his way to discuss issue that is already before a court of competent jurisdiction. You don't do that. I was discussing this matter sometime today with some people. And some of them were saying, they cannot see anything wrong. I said, look, it's a different thing if you had gone there to say there's a 19th count charge against this thing, and that is what we are inviting him to come and answer. As against where you now went out of your way to say he moved this from government house to BDC, changed it, and then to the school. My brother, this is a fact that is exclusive within your own knowledge. If the other man comes, he may tell you a different story, that is not what happened. So are you not saying that your fact is more? And unfortunately, the press, the media, the populace, and so on and so on, they've gone with that position, believing that this is correct. You may not like the man, but our law, the good thing is that the law is there for everybody to follow.
Right. Law is fair to everyone.
For everybody to follow.
Right.
So he must have his day. Just allow him to have his day in court. Therefore, if you are coming now to say you want to bring him in, with all this action that you are taking, why should I trust you that you want to be fair to me, even when you do arrest me? Even when you arrest me, that is, even if I say, okay, I want to voluntarily submit myself, why should I trust you? If anything wrong happens to me, if you are taking this kind of stand now, what then will happen if anything wrong happens to me in your custody?
So you're in support of him not...
I'm not saying, with due respect, I'm not saying, first, for me, left to me, if I'm his lawyer, naturally I will advise that go and attend to this. I will follow him there.
Yes.
I'll follow him there. Go and attend to this. They've alleged that these are the things that you did. Since you are innocent, they say, what do you call it? A clear conscience, fear no
accusation.
Accusation. Yeah. So if you don't have any skeleton in your cupboard, there's no problem for you to go there. But again, because of that fear, that was why he quickly took advantage of our law. By virtue of Section 46 of the Constitution, you are entitled to approach the court where you feel that your right is about, or is being, or has been threatened. You go to any state, and that explains why the Kogi State High Court, because that state has a jurisdiction to hear the matter. He said, go to any state high court. That was what the provision of the Constitution said. So he has taken advantage of that. What is wrong with that? The law is not about emotion. It is his right. Yes. And he has a duty to enjoy that right. And that is exactly what he has simply done. As to whether he did all those things, it's immaterial until you go before the court of competent jurisdiction. So I won't stand here to begin to defend him concerning whether those things are true or not. I will not do that as a lawyer. But what I can say is that if the steps and the procedure that the body established by law, because it's a creation of law, and mind you, whether the state high court, FCT high court, and so on and so forth, these are creation of the Constitution. Right. The EFCC, for all intents and purposes, is a statutory body. It's not a creation of the Constitution. It is out of the power given to the executive that body was created. So you now ask yourself, which one is superior? Therefore, if there is an order coming from a court of competent jurisdiction, nobody under Section 287 of the Constitution should disobey that order. That's why I say it is binding on all over the Federation. It will be enforced. So since those orders are there, the body vested with the power to investigate, arrest, and then go ahead to prosecute, has a duty to maintain status quo. So very well.
On the matter of this $720,000, I understand the case had been on for some time, and the court, hearing the matters, told the school, don't make a refund to the EFCC. Continue to provide the service that you've been providing to those children. Yeah. But we were shocked to hear that the school
has refunded.
Yes, has refunded the money. What is the implication of refunding the money, the sum of money that you received from a client to a third party? In law, what is the implication of that?
Naturally, it's like, you know what you call privity of contract. That contract exists between the people who made the payment and the school. It has nothing to do with the third party, which is EFCC, who is asking them to refund him. And the implication, therefore, is that by virtue of that contract, the school is bound to the person who paid that money. It is not bound to EFCC. Although, except where it can be established by EFCC, that very money is a product of crime.
Yes.
So if you trace it and becomes a product of crime, of course, it's of no moment, talking about the money in question. But that can only be done when a proper trial is conducted. In the absence of any proper trial for which a court of competent jurisdiction had made a pronouncement, that money continues to inure in favor of those that have used it in their transaction. So it does not lie in the mouth of a third party to not say, because it is criminal, return it, and the school quickly do what? Rust and return. Meanwhile, there's a substituting court order.
Yes.
Indicating or telling you, look, stay action concerning this money, don't really continue to render services. For me, that in itself is contempt of court by the action of the school, number one. Again, it is under, because when that happens, and the school is about to be brought before the court for that contempt,
yes,
they will bring the third party who took this money away from them. And that is EFCC. They will not they come and tell us why we will not have cause to imprison you.
Because they were aware of that court order.
Yes, because that court order, with all due respect, was something that you carried out between yourself. EFCC, I'm sure, would have been served with that court order.
Yes.
Even before they went to
party to the matter.
So you cannot, so those are the danger in this kind of this that they are doing. So you see a very beautiful case that they have. They are indirectly doing what? Creating problem for it. And before you know it, one court case will come, the injunction, a matter that ought to last just 3 months, 4 months, they are through with the case. It will now linger on.
7 years. That's
because those technicalities will have to go out first before the real issue is dealt with.
So what then is the hope for cases like this? Because you already mentioned now that if this is how things will be done, because ordinarily it won't take more than 3 months to handle this case, what then is the hope for prosecution of cases?
It still goes back. That is why I said, for me, the action, especially that press conference that was conducted, it shows, with due respect, of an institution that is, inclined towards impunity rather than the rule of law. That's my thinking. Because if it is guided by the rule of law,
yes,
he will know the bus stop, he will know the border. He will know when to move and when not to move. You are not in a hurry. I mean, for all intents and purposes, criminal matters do not have expiring date in terms of offenses of crime. It doesn't have. So whether the person evades, you know where you will get him. And you get him. And it would have been better if the man has if the institution has even kept quiet. They can even at the airport before they pick him there.
You know what I was even saying? If you look at the way this Ganduje matter went, the same judge that suspended him was the one that they went before and argued their matter before him. And the judge revoked the suspension order. That is the process. You either go back to that court or go to a superior court to have the order vacated. This was what they didn't do. And they just set out to arrest the man.
That's impunity.
The point has to be made that no matter how bad you feel about a court order, where we respect the rule of law, the court order must be obeyed. There was a time when Lamidi Apapa of Labour Party was parading himself as the chairman, national chairman of the party, because they got a restraining order against Abure. They waited and waited. Abure waited and waited. By the time the appeal court vacated that order, have you seen Lamidi Apapa parade himself as national chairman again? Abure has been going on parading himself as chairman. So these lawyers know the process.
Right.
Even if you have a cast iron evidence that Yahaya Bello stole all the money meant for Kogi, that was such a reckless thief, you still have to follow the law.
Right.
You follow the law, the right process, the same way Ganduje got the court to vacate the suspension order. Now he's going around, he's doing his work. Exactly. You will have succeeded. You do not win court cases on the pages of newspapers. True. You do not win court cases in the court of public opinion. True. The EFCC has to change its methods and tactics. I was speaking with a friend, a very good friend of the chairman. I said, look, I don't have anything against this man. I was praising him with the energy with which he started the work. But if you do something wrong, I will tell you That is my character. Even if you are the one paying my salary, I will tell you there's nothing you can do to me.
Exactly.
It's as simple as that.
Absolutely. Final thoughts, Messiah. You just have about 30 seconds to wrap up on this.
Go ahead. Yes, for me, I think EFCC should wait. By 15th or 10th of May, if I'm not mistaken,
10th.
there will be a ruling concerning this matter. And I think by then, the ruling or whatever that is coming up would have given the leeway as to which path to follow. But in the circumstance, I will advise them to hold their gunpowder, because whether you like it or not, it still falls within their power to carry out, to go about, because what it will mean for me is that it simply means they already have the evidence.
Right.
The moment is arrested, straight to court. Not the one you arrest. You keep the person and say, I'm going for 14 days or 20-something days. That is another one that they may probably want to bring up again. They will not keep the person for about how many days? Say they want to get a court order to. Meanwhile, you'll be pursuing this. Meaning that if you have something, it means that you already concluded your investigation. You have them already with you.
Right.